Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we are going to talk about apex witnesses. But right now, let's head on down to the beach and discuss that. Let me apologize before I go further. As I'm making this video today, it is thunderstorming here, and try as I might, I may not always be able to get my words in between the lightning strikes, so please forgive me. Well, there are many days I wish sometimes that I could wear those sunglasses throughout the entirety of these videos because I have lights all around me, and they can be quite harsh on the eyes. Anyway, today we're going to talk about apex witnesses. What is an apex witness? Well, let's take the traditional trucking accident case, right? Somebody is driving a UPS delivery truck and he's on a delivery route and runs over somebody's foot, let's say, and they file a claim against the company, the UPS company. And they say, hey, your driver was negligent. Well, in a normal lawsuit, you can get the driver, you can get his deposition, you can get his manager's deposition, you can probably get components of his personnel file, you could certainly get his traffic record and driving record and that sort of thing. But that's pretty much where things cut off. You're not going to be able to get the president and CEO of UPS to sit for a deposition in a situation where nothing he says would be relevant to a simple negligence case. But not all cases are so simple. And a lot of times it isn't the actions of the person, for example, driving a truck, but rather the actions of people who are putting together a plan or a scheme. One of the things that frequently happens in a case is you'll have a company that is engaging in a fraudulent scheme or a scheme that will eventually lead to allegations of antitrust conduct, where, for example, people are trying to squash competition through some kind of alliance or agreement. And what happens in that situation is you have people at various levels implementing parts of the plan. And inevitably, what you also have is somebody who works in one of these companies saying, hey, this isn't right. And they blow the whistle on it, and an investigation starts. And instead of going after the people who are the low-level employees who are engaging in some kind of scheme, the lawyers instead go after the apex witnesses. That's the chief financial officer, the chief information officer, the chief legal officer, and the CEO. And they do this because they have the most relevant information on the plan or scheme. Now, inevitably, what happens is you have people with what I would call plausible deniability. Oh, I had no idea that, my employees were engaged in a scheme to defraud Medicare. I had no idea that somebody was trying to squash out, company ABC because, we appreciate competition. We like the idea of competing. It makes us better. And they offer a lot of platitudes and they'll say a lot of stuff. But normally what happens is, in addition to getting them as a witness, you will get all of their emails. So recently as yesterday, the court in New York in the J.P. Morgan Chase versus the government of the Virgin Islands, the plaintiffs in that case were able to secure an order from the district court that allows them to get the emails of J.P. Morgan's CEO, Jamie Dimon. And if they get those emails and they find anything in them that is worthwhile and useful, they will certainly use those in a deposition where they will call him, put him under oath, and ask him questions about it. That could be very problematic for their defense. It could also be problematic for Mr. Staley, who is also a defendant in that case. It could help a lot more than one person, and it could hurt a lot more than one person. But the purpose behind going after an apex witness is that's where the buck stops. Right? The CEO is where the buck stops in a company. In some companies, I guess you could say it's the chairman of the board. However, in many companies, the chairman of the board is also the CEO. So there are a lot of things that you have to look at in a situation like that. And a lot of times courts do not allow, at least early on, any depositions of corporate officers and directors because it would intrude into the normal operation of the company. Where you get information from a document or from a deposition that says, well, yeah, I told the chief financial officer that this was a problem, or something to that effect. Well, now you're going to get, at the very least, the emails from that person, and you're probably going to get that person for a deposition. Now, the federal rules of civil procedure normally will limit the amount of time somebody has to be in a deposition. It's usually either 6 or 7 hours. And inevitably what happens is this very thing. You have somebody who is being deposed, and the first question is, state your name for the record. And after that, it's like, you're the CEO of, XYZ Corporation. And the lawyer on the other side says, well, I just want to make an objection. And here is my objection. I think that question is inappropriate. Now, of course, he's allowed to make objections. He's not allowed to make frivolous objections, but he is allowed to make objections. But they have to be meaningful, and they have to say something like object to the form. He can't make a speaking objection. If you ask somebody, would you in the normal course of business receive reports from your Tampa office, then he can make an objection to calls for speculation, but he can't instruct the witness not to answer. The only time he can instruct the witness not to answer is when it invades a valid privilege or an immunity, for example, the Fifth Amendment. You can't instruct the witness not to answer under the Fifth Amendment if there is potential for being indicted later on over the same acts. But it is quite common for lawyers in depositions, irrespective of those rules, to make long-winded speaking objections and put all kinds of stuff on the record. Not so much because they want it on the record, but because when they're talking, the person taking the deposition is not asking questions, and it all burns through the time. So what a lot of plaintiffs' lawyers do is they bring somebody with them to act as timekeeper. And every time that the defense counsel objects or starts a colloquy with the other attorney, they tap the stopwatch and they put him on the clock. And then 4 hours into the deposition, they might say something like, well, I'm letting you know now that we've been going for 4 hours. By rule, we only have 3 hours left, and you have spent 1 hour and 10 minutes making objections and speaking during the period of time when I'm supposed to be getting information from the witness. So I just want you to know I'm going to extend the deposition for that period of time at the very least. And if you don't like it, quit making so many long-winded objections. Now, that doesn't always work. A lot of times lawyers and judges will object to that and be rather ugly about it. But the bottom line is, if you only get 7 hours to take a deposition and you have 1,400 different emails that you have to go through with the witness, you need the time to do that because it takes time. And sometimes you have to have somebody sit for a deposition for 2 or 3 days in order to get through all the material. Good judges will let you do that because they know that discovery and being prepared for discovery is usually what wins cases. So at any rate, we now have JP Morgan Chase's CEO, Jamie Dimon, being on the hook to provide his emails, and most likely he will wind up sitting for a deposition where he will be asked all about what happened with that financier who suffered an untimely passing in the jail cell in New York City. That might be a situation where you'd want to bring popcorn. Now, normally, these depositions are video recorded. Usually, if the case settles, there will be an agreement between lawyers not to share those depositions. And sometimes, if they can't get that agreement, they will go to the judge and ask the judge for an order limiting disposition of those documents and information. And sometimes they are effective. But here's the other interesting little piece about that. Let's suppose that in the course of litigating the case, the defendant files a motion for summary judgment. And the defendant says, you know, it wasn't our dog. It didn't bite you. If it did bite you, you deserve to get bit. And what are you hollering about? You weren't hurt anyway. So that's what the summary judgment motion says. And now, in order to demonstrate that, they take 2 or 3 select clips out of this video deposition and provide that to the court. Well, if the court relies on that for its ruling, in the federal courts at least, that now becomes public information because the public is deemed to have a right of access to the courts. Now, that doesn't mean necessarily that you are automatically going to get it, because a lot of times lawyers will have gentlemen's agreements saying, hey, we're not going to release that to anybody. But if the court relied upon it and it's in the filings, then most of the time you can go to the court and make an open records request and get the information that you seek. A lot of people don't realize you can do that, but you absolutely can do that. That's how journalists make a living sometimes, is going through court records and finding information that other people might very well wish to keep hidden. That's what I have for you today. Hopefully you found this interesting, educational, and maybe in some ways a little funny. If you have an opportunity today, please go out of your way to help somebody. Thank you so much for watching. Have a marvelous day. I'll catch you down here at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.